All right, welcome to Liberal Dan Radio here on YouTube. You can hear me live Wednesdays at 8 p.m. Central, either here on youtube.com/liberaldanradio or on Blog Talk Radio /liberaldan. And last week I did a podcast, and part of that podcast included a discussion of Kyle Rittenhouse and some of the novel concepts that Rittenhouse's defense have brought up as to why he should be considered to have been legally carrying the weapon that he was carrying. So, and this video happened to get a lot of people responding to it, including this YouTube user, Johnnie Walker Dread. And I'm just going to say, first and foremost, thank everybody for responding and commenting. For the most part, there were some people who, maybe threw some insults around, and whatever, that happens from time to time. It's the internet. I'm used to it. I'm thankful that there was no, hey, you're fat, because that happens all the time. It's why I have my fat man rants that I post on my channel. But I do appreciate civil discussions with people with whom I disagree. Because sometimes, maybe I change their mind. Maybe they change my mind. Maybe they show that I have been either inaccurate or indelicate in how I've described an issue. Maybe I need to be a little more precise and a little less vague or general in discussing things. There was one such instance that took place here, and I do appreciate them pointing that out and showing where I could have been better in making my argument. There are other things where I still disagree with these individuals on this individual subject. But again, here, is Johnnie Walker Dread. I do like the name, by the way. It's clever. So, thank you for responding. And he created this video in response to me. And so I feel we'll probably have a back and forth and response videos, which is cool. I like doing that. So without further ado, let's see what he has to say.
Well, we found another one. Liberal Dan, as he calls himself. He's going to weigh in on Kyle Rittenhouse.
Okay, so just want a little introduction for those of you who don't know me. I did not come up with the name Liberal Dan. I do call myself Liberal Dan. There is a conservative radio talk show host down here in New Orleans who was originally from up north. Up north, you might have known him as Ozone. His name is John Osterland, and I would say, hey, I'm Dan from wherever I was living at the time. And he'd be like, oh, it's Liberal Dan. And so it stuck. And then I would meet people unrelated, and it would somehow come out that I'm the guy that calls in under the name Liberal Dan. And they'd be like, oh my God, you're Liberal Dan. And the first couple times, it was just like, what? Why are you excited to meet me? I'm just a caller to local radio. But I guess it was exciting enough for them, to be able to, hear the, I guess, local celebrity, I guess, of what I was. I wouldn't call it that, but they were excited, so fine. I decided to go ahead and embrace the title and, got the domain name up and running, started the podcast. I had done some radio a little bit beforehand, but I've been doing this podcast for a while now. And so that's how I came to be Liberal Dan. So let's continue.
One of the most sophisticated, crazy court cases to come down the pike in the last 50 years. And he's going to decide that, well, who cares about reading any of the background material? Who cares about following any of the news? Let me just read an article and then I'll weigh in on it.
Now, here's something that, he's assuming bad faith on my part, and it's coming from ignorance because I could clearly say that he has not listened to my show before. He has not, heard me discuss this case before. I have other videos which he later plays that I've talk about the other video that I made about this. I've discussed Rittenhouse on my podcast. For him to just assume that I read this one article and decided to now weigh in on it is a false statement. Now, he may not have realized that it was a false statement. Maybe he just made a bad assumption. So I'm not going to say that he's lying because too many people throw that word around incorrectly, but he is making that statement out of ignorance. I have looked into Wisconsin state laws, and we obviously disagree on what the law says too, which will be discussed later, but I've read many articles about what's going on with Rittenhouse, and I was willing at the very beginning when I started looking into this case to give him, Rittenhouse, the benefit of the doubt when it came to what was going on because, here's this 17-year-old in a situation and really well over his head. And at the end of the day, I reached my conclusion not because of reading one article, but because of reading many articles and sources etc., and listening, mind you, to people on both sides of the aisle as well to try and get a variety of opinions to help me form my own opinion. So let's continue.
All right, Liberal Dan, you tell us what happened that night in Kenosha.
Because under Wisconsin law, there are certain check boxes that you need to check in order to justify a use of force: to defend yourself with deadly force and to defend property with any force.
Now, notice he kind of sounds like he's a reasonable person here. And listening to this, you might think, well, okay, he seems to know what he's talking about. No, he doesn't. When he gets into the details, you'll find out that he's got certain things missing.
And I clearly go over all of those instances where, Kyle Rittenhouse, you can't, for example, you can't be committing a crime and then claim self-defense.
That's simply not true. He's misreading Wisconsin statutes. What the statutes say is that if you're committing a crime, the presumption that you are acting in self-defense disappears. So in other words, you can't be guaranteed to have been acting in self-defense if you are committing a crime. But that doesn't mean that you can't claim self-defense if you're committing a crime. You really think that jaywalking negates self-defense? Really? You really think that somebody could go over there, open fire on protesters, and the protesters, they cannot shoot back because they're breaking curfew? Who out there really thinks that? And as proof, on my own show, I disclosed the state of Wisconsin versus Coleman.
Okay, before we get into Coleman, let's talk about the other two things that he said. It's one of the areas where I admit that perhaps I either indelicately or incompletely, or incorrectly stated what my view should have been on this. Clearly, jaywalking should not prohibit somebody from then protecting their own life. So if I'm crossing the street in violation of the traffic code and somebody attacks me and I fear for my life reasonably, I can use deadly force to protect myself. And that clearly that could happen. But it has nothing to do with what was going on, because one has nothing to do with the other. Me crossing the street illegally has nothing to do with the act that I'm now defending myself because somebody attacked me for it. Whereas, if you go on the other side of the coin, and if somebody broke into a house, regardless of whether or not they're armed, if somebody broke into a house and then the owner was there and the owner started attacking them, and the person who was breaking into the house decides to shoot in self-defense, no, you obviously cannot claim self-defense in that case. And I think we both would agree on that, because you put yourself in that situation, you put yourself in the dangerous situation, you created that, you provoked what happened to you, and as such, you're no longer able to act in self-defense. Now, if you want to go back to maybe let's make a ridiculous, and I'll freely admit that the situation is ridiculous. Let's say I decided to put on a rifle, strap a rifle to my back, and I was going to continuously keep jaywalking. And the reason that I had the rifle was in case my illegal jaywalking ended up causing somebody to, be coming at me in a vehicle, and I feared for my life because I might get run over by this vehicle that was coming my way, and I decided that the best way to protect myself was to shoot the driver. I could not then claim self-defense either, because I put myself in a situation, and I'm not reasonable in thinking that that's the way to defend myself. That's not a reasonable thing to begin with. So, and I would argue that, that Rittenhouse is much closer to the breaking and entering side of things than he is to the jaywalking side of things. And if you're sitting there and you're counter protesting a Black Lives Matter or Antifa protest that protest was protesting police violence, and you were on the other side of that protesting or counter protesting, and somebody shot at you, then you would be able to use deadly force to shoot back, because you're not necessarily doing anything to provoke. But that's not what he was there for. He is on video, and I've shared this in the comment sections below, admitting that he was there to defend a property. He and give first aid or whatever. Two things that he's not trained to do. But he wasn't there to counter protest. He was there to defend property, which he's not legally entitled to do under the state of Wisconsin laws. So he was violating curfew. He was, according to the prosecution, carrying a weapon that he was not legally entitled to carry. And his just being there, and I've seen video where he was, they were up in each other's faces. Now, we don't have video of the entire night. So maybe there would be a video that would release that might shed some light on to what happened before each shooting that took place. However, I would argue that, again, Rittenhouse is much closer to the putting himself in a dangerous situation that he then is trying to use as an excuse to shoot people than he is to jaywalking. Now let's continue. Let's hear about Coleman a little bit.
Firearm on him. He's a convicted felon. They even had a warrant out for his arrest. He'd already been convicted of a felony, and they had a felony warrant out for his arrest. The police did a no-knock bust into his house at night with a warrant. He opened fire on the police. Guess what? He claimed self-defense, and the Supreme Court of Wisconsin supported him.
Well, here's the difference between Coleman and Rittenhouse. Coleman wasn't out past curfew. Coleman wasn't walking around with a loaded rifle. He was in a house. He was in a personal dwelling, and the police did a no-knock warrant, as he said. Now, Coleman knew that there was a gun in the house, and fearing for his life because he didn't know who was coming through that door, he ran and got the gun. And then he came back and he was waiting at the door with the gun. So the police officers came through. He realized, oh crap, this is the police. This isn't just some criminal breaking into my house. He put the gun down. I don't believe he has it right that he shot the police. Maybe I don't remember reading that he shot the police. I don't know if he let one round off or not, but he's still living, so he probably didn't shoot. But that being said, once he realized what was going on, he put his gun down. It was like, nope, we're not doing this. So clearly there's a huge difference between the Coleman case, where he was not out past curfew. He was not doing other illegal activities. He only grabbed the gun when he felt his life was in danger. Rittenhouse was walking around with the gun the entire night.
Whether or not committing a crime negates your self-defense depends on how strong the nexus is between the crime that you're committing and the actual event.
And that's a very good point, and I would like to highlight this point. Yes, and this is probably where I either indelicately or inaccurately or whatever you want to put it, I'll apologize for not making this point as part of the argument. He adds a good point to it, so I will alter my argument in order to take into consideration this correct point. The nexus, or what makes the actions that were being done by the person claiming self-defense around, the crime that they were committing and the self-defense, however tightly coupled they are, will then determine, whether or not the actions negate the ability to declare self-defense or not. Clearly, jaywalking, there's no coupling that going on, none whatsoever. So clearly, if you're jaywalking and then somebody attacks you in the middle of the street trying to kill you, you have the right to use deadly force to defend yourself. If you're in the breaking in the house and you're trying to rob some house and the owner of the house is there and starts going after you and starts trying to kill you for breaking into the house because they're in fear for their lives, justly and correctly, you then have no way to claim self-defense. Why? Because, you're tightly coupled. Your presence there is very tightly coupled to the reason why the other people are going after you. So I would argue that, again, Rittenhouse's actions are much, much closer to the breaking and entering. I'm not saying he broke and entered. I'm just saying that his actions are much more tightly coupled than jaywalking. We'll just leave it at that. Let's go on.
Only a bonehead like this dude is going to go around thinking that if you're committing a crime of any sort, you cannot defend yourself. Nobody out there with any legal understanding believes that.
Okay, and so look, maybe I stated my opinion in a boneheaded way. And I'll say, look, yes, I was wrong in saying that all crimes would negate self-defense. And that it is more correct to say that the more tightly coupled your crime is to the actions that cause you to claim to act in self-defense, the less likely you're going to be able to make a correct self-defense claim in court. Jaywalking, clearly not. But I would argue that in Rittenhouse's case, his crimes are more tightly coupled. So how I should have worded it, I guess, is his crimes that he committed that night would prevent him from declaring self-defense correctly. If he was shown as the aggressor, he would have to then leave the area. And
you mean that kind of like what he did?
No. And this is probably where we're going to have a disagreement on this issue. And I don't think I'm going to change his mind. He's probably not going to change my mind unless he were to provide additional video evidence of the night that I hadn't seen yet, showing him leaving the area and clearly giving up the fight, clearly stopping the fight. Because that's, if you're the aggressor, and I would say that after the first shooting, that probably everybody around him was like, this guy's an aggressor. He just shot someone. So that's probably what the people were thinking when they were chasing him down, trying to prevent him from shooting anybody else. Now, he's going to argue that his running away in and of itself is enough to say, I give up, I surrender, or I give up, I am no longer fighting you. But you can, just because you move to a different place on the map, it doesn't mean you've surrendered or you've stopped fighting or you've done whatever it is you need to do to declare yourself eligible to now defend yourself. It could just mean you're putting yourself into a better position from which to shoot people again. You know, getting a better position isn't retreating. Getting a better position isn't giving up the fight, isn't clearly, maybe if he would have had his hands up and would have audibly said, look, I don't want to shoot anybody. I was shooting this guy in self-defense. I felt my life was in danger. Please don't come after me. That's the only reason why I shot him. If he would have said that, then perhaps, and then if the people would have started to continue to attack or chase or try and hurt him, maybe at that point, his continued firing of shots would be deemed by the prosecution to be justified. But there's no video evidence of him doing this and saying, look, until I think at the very end when he was approaching the cop cars after his final shots, he then raises his hands once he sees the cops. But there's no situation, and at that point when his hands were raised, I would say that's the point that he gave up. That's the point that he stopped fighting. Not any time before. Had he done this, had he raised his hands up in the air and said, I am not wanting to fight you, I was just defending myself from this person who I felt was a danger to my life, and had he done that, then we wouldn't be having this discussion at least about the other two individuals. But he didn't do that. He didn't make it clear. And in my reading of the Wisconsin law, you have to make it clear. The onus is on you to make it clear. You can't be vague about it. You have to clearly say, I'm no longer fighting. Stop. I'm not fighting. My hand's off my weapon. I'm not fighting you. I'm not going to shoot at you. We need to stop this. We need to take a break. I'm not doing anything threatening to you. Let's stop. He didn't do that. So it wasn't clear enough that he did. And maybe he was ignorant of his requirements of doing that because of his age, inexperience, lack of training, etc. But ignorance of the law is an excuse to break the law. So let's continue. Show that he's left the area to establish himself, kind of like in football, when somebody goes out of bounds and they have to reestablish themselves as a valid receiver. You have to, if you were an aggressor, then you have to basically run away for a second.
let me think here. If you're the aggressor, and no, by the way, nobody's claimed that he's the aggressor yet, but let's just assume that he was, he has to leave the area. He has to run. That's kind of what he did.
And
Say,
not what he
look,
did.
I'm no longer here. I'm giving up. I'm not doing anything to you. I'm giving up. And it has to be significant. Like,
Yeah, significant, like running away from the person. That's kind of significant.
Kind of significant is not clear. Let me read specifically from the Wisconsin state law. The privilege lost by provocation may be regained if the actor in good faith withdraws from the fight and gives adequate notice thereof to his or her assailant. Adequate notice thereof is the key terms. The notice has to be adequate. And I would argue, if I was the prosecution, that simply repositioning oneself while running is not adequate notice. Adequate notice would be, I give up. Let's stop. Hands up in the air. We are not, I don't want to continue doing this. We need to stop. Period. He never did that. He never raised his hands until he was by the police cars. So to me, at that point, he gave adequate notice that he was no longer wanting to fight. But at that point, the police were right there as well. Up until that point, I don't believe he gave adequate notice.
have to convince the people. If anything, there are people who saw him shoot the guy in the head. If anybody, it's possible that those people were considering that they were committing acts of self-defense or defense of other people.
Yeah, another person who's not a lawyer, he doesn't get it. It's a common myth amongst a lot of people, is that if I am claiming self-defense against you, that negates your claim of self-defense. It's actually quite possible for Kyle and his attackers to be all acting in self-defense at that time. And there's plenty of examples where this can happen, and the Kyle Rittenhouse shooting is one of them. And the reason why this can happen is because if you read the way that the statutes are written, it's all about what the person who's being attacked believes. And therefore...
And let's stop there, because that is a very important point, because he says it depends on what the person believes. But that is not the words of the law. The words of the law is that the person has to reasonably believe it. What a person believes is irrelevant. What a person reasonably believes. Somebody has to reasonably believe that something is a threat to their lives. If the belief is not reasonable, it is not valid either. So this is an important point that Johnnie Walker Dread needs to consider, is that just simply believing it to be true isn't enough. That belief has to be reasonable.
Or if you're being attacked and you believe that the interference of the other person is unlawful and a deadly threat, you have the right to self-defense.
Again, it's not just belief, it's reasonably believe. If your belief that you have the ability to defend yourself at this point, and that belief is not reasonable, you're not entitled to that act of self-defense. Then that act that you're claiming of self-defense is criminal.
However, the person attacking you, he might believe that you pose a serious threat to bodily harm to him, and therefore he can claim self-defense.
Well, he can claim self-defense all they want, but if it's not a reasonable belief, again, he doesn't have the right to take that action. So that again, it's a very important point. The belief must be reasonable. Furthermore, whether or not your belief is reasonable that the person is going to kill you, there's also the other factors that come into play, is who is the provocateur. So both parties might very well claim self-defense, but if there's a clear person who's provoking and a clear person who's being provoked, then only the provoked person would be able to claim that, even if both people are reasonable in their belief that the other person is a threat to their lives. Because, again, both people can claim self-defense. Everybody can claim self-defense if they want to. But in order for it to be a valid claim of self-defense, the belief that their life is in danger has to be reasonable, and they need not be the provocateur. Period.
But none of them he fit. There's no boxes there that he checked. So he is not allowed, under Wisconsin state law, to defend that property with any amount of force, let alone deadly force.
Well, okay, a few things. There's no boxes to be checked here. That's not how Wisconsin self-defense laws are written.
Yeah, there's no literal boxes that have to be checked. Yeah, I mean, it's just a metaphor. So in order for you to claim self-defense, one of these things have to be true. So if you made a checklist of all of the possible ways that you could claim self-defense, as long as you check one of them off correctly, you have an adequate, correct claim of self-defense. So if he doesn't check any of those boxes, proverbially, he can't claim self-defense legally. His claim of self-defense will be denied in a court of law.
But more importantly, it doesn't make any difference whether Kyle said he was out there to defend property that night, which he was doing at one time. He had left the property. He was no longer protecting it. Whatever laws there are about defending a property and self-defense are moot because he wasn't defending property at the time. He had walked off the property and was walking down Sheridan Street when he was ambushed by Joseph Rosenbaum. The fact that he was guarding property earlier in the evening, completely irrelevant.
I disagree. It goes to his intent. His intent of being there was to defend property and give first aid. He is not trained to do either of those things, but that's what his intent was, to be there. That was his intent. So to ignore his intent on being there is to willingly decouple something from his actions that should not be decoupled. It should he was violating curfew. He was carrying a legal weapon according to the prosecution, and he was trying to protect property that under Wisconsin law he has no right to do. He has no right to defend the property because, again, there's a certain group of people who can defend a particular property with force. So, not even deadly force, just force, because you're not allowed to use deadly force to simply protect property in the state of Wisconsin. You're only allowed to use deadly force if you're protecting somebody's life while protecting somebody's property, but only the owner of the property, a member of the immediate family or household of the property, or an agent or a manager who works at the property, or somebody who's an employee of the property is able to defend the property with force, not deadly force. You can't even threaten deadly force unless it escalates to beyond damage of property or theft of property. So, and it's important to notice that he is, again, it's another thing that he's trying to do that he doesn't have the right to do. A lot of people, and I'm not saying that this user, that Johnnie Walker Dread, is applauding Rittenhouse for being there defending people's property. But there are other people who are saying he was just there defending property. Well, he had no right to do so, and it shows his intents were again extra legal. When he was saying that he was there defending this property, that they were not just there defending this property, but all property that was there, that they felt that it was their responsibility, him and the other people that were with him, to defend property in an armed way from the people who were there protesting the police action. And they don't have the right to do so. They don't have the right to use force to defend property. They had no right to do so. So it extends to what his intent was that night. And that's why I think it's relevant.
Because it seems that they've now changed their minds. According to NBC News, hunting laws allowed Kyle Rittenhouse to carry a weapon during fatal shootings in Wisconsin, lawyers say.
Oh, for Christ's sake, why don't you get your news from another source or actually watch the actual proceedings so that you can hear the actual attorneys talking?
And here's the thing, again, another time where he's assuming bad faith on my part, as if this one source wasn't the only one that I looked at before talking about this on my podcast. I happen to read from one source, but that doesn't mean that I only looked at that one source. So that's a big difference. And you're making an assumption based off of your existing prejudices about, I guess, how you feel about liberal folks, and fine, whatever. There are liberal people who are in the media who I've ridiculed and criticized from time to time because I felt that they were not acting in a way that was honest or sharing the facts properly. I'm not beyond criticizing my own side of the aisle as well. But so perhaps because of those other people, you have you feel justified in maybe assuming that I would only look at this one before making my arguments. But I looked at other ones. So let's go on.
The attorneys for Kyle Rittenhouse did not change their argument. What changed was the fact that NBC News decided to screw up the headline, and they roped people like you right into it.
Prosecutor Thomas Binger dismissed the defense argument and said Rittenhouse attorneys should tell a jury he was hunting on the streets in Kenosha. Now, if that doesn't show that they're admitting intent, who was he hunting? He was hunting people.
No, that was Binger's argument.
And if you wait for a second, you'll see that I acknowledged that I somewhat misspoke my argument, and then I corrected my saying so. But he doesn't then acknowledge the fact that I went back and said, yes, this was the prosecutor saying it. So it's a little bit of dishonesty here on the part of Johnnie Walker Dread. So
Binger got it all screwed up too.
That's actually the prosecutor saying that. That's right. So the prosecutor said that. So the defense is basically saying he was hunting. Yeah.
No, the defense is not saying that.
Lawsuit that he was there under no good.
According to the lawsuit.
Yeah, I said lawsuit wrong. Get over it. Okay. Yeah, I said lawsuit instead of trial. Yeah, I misspoke one thing. I'm sure you've never misspoken anything in your life before. But here you go. Here's the thing. The defense is making the argument that hunting statutes allow him to hold that gun, despite the fact that otherwise he wouldn't be able to hold the gun because he's under 18. So if there are exceptions in hunting, then therefore you have to be hunting to use those exceptions to the general rule of you're under 18, you can't hold this weapon. So again, if the judge rules that the law is written in an improper way and creates this legal vagary that needs to be cleaned up in the law, fine. That's beyond my pay grade. But at the end of the day, if the rule is there, if the law is there for hunting purposes, then you should only be bringing it up as an exception to the general rule of if you're under 18, you can't hold this gun if you're hunting. So was he hunting? No. Then it shouldn't apply. Period.
Schroeder said that the state statutes were unclear and he wanted to review the laws and revisit the matter later.
Okay, so if Judge Bruce Schroeder, a judge, is coming in and saying, hey, it's not real clear here, I'm going to need more time to examine this, then you might have went back and thought, I must have it wrong about what the defense is claiming. Because if the defense is claiming that Kyle was out hunting that night, the judge would have thrown the defense's motion out the window right then and there.
Well, the defense is saying that the hunting laws, the hunting exceptions apply. How else could the hunting exception apply unless he was hunting? Or, as I've said already before in this video, that maybe the law is in fact poorly written and the judge will determine that if the law is poorly written, creating a loophole that or a vagary in the law that would then say, okay, maybe but to me, it's the defense grasping at straws, trying to say that hunting laws allow for him to possess the weapon that night, when the only thing that hunting laws should do is make an exception for people while they are hunting. And, I tend to be a person who thinks that the intent of the law is important. And a conservative will often say, well, the intent of the law is not important. We should be textualists when we're looking at the law, when we're looking at the Constitution. But then they'll cite the Federalist Papers, which just explain the intent of the Constitution. So I don't get conservatives on that point. They want to be textualists, from your commentators on YouTube all the way up to your Rand Pauls and Ted Cruz's and Everybody else who's conservative, who wants to insist that judges be strict textualists, and then they go cite what the founding fathers said in the Federalist Papers. That's using intent to interpret the law as written. So you can't have it both ways. And I do think, like, sure, let's look at the Federalist Papers to see what our founding fathers meant when they wrote the Constitution. Just like we should look at the intent of the law and use, I hate to say common sense, because there's no such thing anymore. But if a law is written to make exceptions for people who hunt, then those exceptions should only count when you're hunting. It shouldn't be that difficult.
If that's the argument that they're going to use, they're screwed. I think Rittenhouse is going to go up a creek and be sent up the river, sent down river, sent buried under the prison, whatever you want to say. That's Rittenhouse. Anyway, let's go ahead and take the first commercial break. We'll come back, take your calls as well.
All right. Notice how he smiles when he starts talking about Kyle going up the creek and getting put under the prison. You see what I'm talking about?
My smiling there is at the absurdity that one would use a exception to the law written for hunters to justify carrying a weapon on the streets of Kenosha that night. That it's the ridiculousness of the argument that is making me smile at that point. I'm not happy that anybody has to go to jail. I wish Rittenhouse wouldn't have been there in the first place. That he would have just cleaned graffiti earlier in the day and just left it at that. He had no business being there. He was not trained to defend people, defend property, to give first aid like an EMS or whatever. He had no business being there. And I think there were a lot of people who failed Rittenhouse that night. But he still should be old enough to understand that doing certain things are wrong. And that his actions, in my opinion, that night were wrong. And we will see at the end of this case whether or not a jury agrees that his actions rise to the level of criminality and as such send him to jail. I'm not joyful that anybody would go to jail. I'm just amused at the absurdity that is sometimes brought up by criminal defense lawyers. And look, don't get me wrong. We need criminal defense attorneys in this country. You know, they play a vital role in protecting our system of justice and making sure that our system of justice works. It's just that some defense attorneys come up with some doozy arguments that make everybody just want to shake their head. And to me, any argument that says an exception written for hunters should apply in a non-hunting situation, you're reaching for straws at this point. So
He wants Kyle convicted. He doesn't care if Kyle's guilty or not.
And again, that's also not true. I don't want anybody who is not guilty going to jail. And if the prosecution fails to prove its argument in court, then he won't go to jail because the prosecution will have failed to prove their case, and he would, at that point in time, should be treated as innocent under the law. So I only want him going to jail if he is in fact guilty of the crimes that he's being accused of. And I think he should go to jail if he is guilty of the crimes that he's being accused of committing. So let's be clear about that. I don't want people going to jail just because I disagree with them. You know, I don't think people should be going, be in prison because they have a difference of opinion. No, I think people should be going to jail if they commit crimes. And in my opinion, at this point in time, with all the evidence that I've seen so far, Rittenhouse's actions to me seem to be criminal in nature. Now, I'm more than open. If there's other video that happens to surface that might change my mind, or if there are other people who want to make an argument that will show me why I'm wrong and make me change my mind too, I'm open to that too. Now, to me, Johnnie Walker Dread has not adequately presented a case that would make me change my mind on Rittenhouse's guilt at this time. Now, is it possible that he might come up with other ones? Maybe I'll go watch some of those videos and be like, you know what? In that other video, he brought up a good point, and maybe I might change my mind. Because that's the type of person I strive to be. Somebody who is based on facts, logic, and reason, and not just on, my whim or my feelings on the matter or what have you. I want to see the facts, and I want to see the law, and I want to see how the two play out. So I welcome any additional commentary that you might have on this or any other issues, and I am always open to the idea that I might be wrong and that you might be right. And I hope that you are open to the idea that you might be wrong and I might be right. Just like how you ignored the fact that, somebody's belief that their life is in danger has to be reasonable. You left that out, and I hope you incorporate that into your future videos like I will incorporate the fact that I indelicately or inadequately represented my argument about somebody committing a crime, automatically making them ineligible to claim self-defense. That there does need to be connecting matters there that connect the illegal activities to the self-defense and what you're trying to claim self-defense about. So I've changed my argument because of what you said, and I think it's made my argument better because I've listened to what you had to say and I agree with you on that point. So I hope you will listen to my points as well and perhaps think that maybe some of the things I've said had merit, and if not, then maybe we'll have another round 2 and maybe we'll have that opportunity to take place at another point in time.
Like my video and subscribe to my channel, and be careful about listening to mainstream media. They don't get much right.
And I did subscribe to your channel. I do invite anybody who's watching this video, like it or dislike it. If you don't like it, give it a thumbs down or give it a thumbs up. And share it with your friends regardless of if you agree or disagree. If you agree, say, hey, this guy makes some good points. You should listen to him. If you disagree, say, hey, this guy is a bonehead, like Johnnie Walker Dread did. And, we can have more discussion and more debate on these issues. But regardless of whether you don't agree or disagree, subscribe to my channel as well. I subscribe to his. And I think we could all be better at the end of the day by having conversations like this about this issue, about other issues as well. So again, and you can you can follow me many places online, facebook.com/liberaldan, @liberaldanradio on Twitter, on TikTok. You can go to patreon.liberaldan.com to support the show that way. But the best way, again, to support the show is at this point, if you don't want to support financially or can't afford to support me financially, buy commercials on the podcast or whatever, the best thing you could do is just subscribe right here and follow me wherever I am on social media as well. So thank you very much and have a good night.